Have you ever had an idea so powerful, so unique that you knew it could change your career or even make millions? Now imagine someone else taking that idea without asking and building the success of your creativity. It's more common than you think. Today, we are answering one of the most critical legal questions for entrepreneurs, freelancers, and creators. Can you legally copyright your ideas? And more importantly, what psychological tricks do ideas thieves use? And how can you protect yourself with both law and strategy? This is a space in intellectual property, business protection, and psychological warfare designed for the people who create, build, and think ahead. Let's dive in. Moving forward, the first one, the cold truth. Ideas aren't protected. Here is the brutal truth first. In the United States, you cannot copyright an idea, not the idea of a revolutionary app, not your concept for a field or a new coaching method, not even your $1 million startup pitch. Copyright law protects the expression of an idea, not the idea itself. This means you can only copyright something once it's been fixed in a tangible medium. That could be a written document, a recording, a video, a digital file, a prototype or sketch, your raw ideas. That's just a thought. And legally, it doesn't exist until you turn it into something real. Moving forward, the next one, the four legal pillars of idea protection. Let's break down the four main types of intellectual property, IP protection. First one, copyright. Protects original expressions, written works, songs, videos, software, codes, etc. Does not protect your ideas, systems, or procedures. Second one, trademark. Protects brand identifiers like of logos, slogans, product names, even jingles. Third one, patent. Protects inventions and processes that are new, useful, and non-obvious. Fourth one, state secret. Protects confidential business info like Coca-Cola's formula or a secret algorithm. Only if you take active steps to keep it secret. So what should you do? Turn your ideas into one of the this is protected formats fast. Moving forward with next one. Psychology of idea theft. Why do people steal ideas? Let's look at the psychology. First, envy and ego. Someone hears your pitch and gets jealous. Their self-worth feels threatened. They imitate or outright steal to compete with you mentally. Second, opportunity perception. You share too much too early. They see a legal loophole and jump in. Third one, rationalization. They convince themselves it's different enough for fair game since it wasn't registered or protected. Next, reward bias. They imagine the gain far outweighs the legal risk. If they've been big, what's the worst they could have? Understanding these mental games helps you pre-frame your and protect your work. Moving forward with next one, how to make your idea legally protected. Here's how to legally protect your ideas by expressing them strategically. First, write it down. Create a dated timestamp file. Use Google Docs, email, or even send it to yourself by certified mail. Second, register the copyright. Visit copyright.gov and register the material. Cost as little as $45. Is fast and legally powerful. Use contracts like of NDA, non-disclosure agreements. Use before sharing your pitch. Work for hire contracts. For financiers, you hire. Licensing agreements for partnerships. Next, Create a prototype or MVP. Turn your idea into something that can be touched, shown, or demoed. That's when it becomes harder to copy. Next, timestamp with blockchain for IP wars. Tools like Wipo Proof or services like LegalZoom IP board offer third-party timestamping. Moving forward, the next one, red flags. Whenever your idea is at risk, here are signs someone might steal or already has your idea. They suddenly go silent after you pitch meeting. They ask for specifics without offering anything in return. They powered their product to look eerily similar to yours. They start using language or visuals you introduced first. Be alert. Document everything if needed. Consult a business attorney immediately. Moving forward with next one. Case studies of idea theft and legal outcomes. Let's study three major real-life examples. First, Zuckerberg versus Nicholas Twins Facebook case. They claim Mark stole their idea of a Harvard social network, but they won not on idea theft but on breach of contract and fiduciary duty and pay out $65 million. Second, idea theft in Hollywood. Studios get sued constantly for stealing script ideas. Without a registered script or a signed submission agreement, plaintiff lose. Next, Google versus Oracle API code. Oracle sued Google for copying 11,000 lines of Java API code. Massive trial. Supreme Court sided with Google because APIs are functional and considered fair use. Lesson: it's not just about what's stolen, it's how clearly you own it and how well you have expressed and documented that ownership. Moving forward in next one, brand psychology, protecting perception. The psychology of protection isn't just legal, it's branding too. First, label everything. Put C, TM, or R wherever it applies. It signals that you know your rights and are ready to enforce them. Second, use authority framing. Call your process the proprietary framework, a protecting model, or a certified methodology. Next, don't overshare. Share just enough to spark interest, but not enough to enable duplication. Please don't dump. Next, elevate the story. Make your brand feels like a system, not just a one-off idea that makes it harder to copy and easier to defend. Moving forward, the next one, when to use trade secrets instead. If your idea has ongoing commercial value and it isn't easy to reverse engineer, consider trade secret protection. What counts as a trade secret? Algorithms, customer databases, recipes, manufacturing methods. So caution would be you must take active steps to keep it secret. That means NDAs, internal policy, and restricted access. If it leaks and you didn't protect it, you lose it. Moving forward, the next one, legal psychology for entrepreneurs. Let's flip the game. Here is how to use legal language to protect your business even before you register anything. Say proprietary process instead of idea use, confidential or pre-patent in communications, and emails will subject to copyright. Your name, year. Use terms like internal use only, non-circulating draft, or licensed IP. This creates perceived legal risk in the minds of a bad actors, and that can be enough to stop casual theft. Moving forward with next one, your action plan. Here is your rapid fire to-do list to secure your intellectual capital. First, write or record your idea in detail. Use Google Docs, motion, or audio recording. Second, register it at copyright.gov for written or visual work, at uspto.gov for trademarks. Consider provisional patents if you are inventing something novel. Next, use NDAs before sharing, especially with potential investors, developers, or freelancers. Next, start building it publicly, but wisely. Use social proof, legal labels, and branding stamps. Next, monitor your space. Set up Google alerts for your brand, slogans, or method names. Ideas are cheap, execution is everything. But without legal structure and psychological strategy, your execution can be stolen too. Protect your work like it matters, because it does. If you found this valuable, hit like, subscribe, and drop a comment telling, have you ever had an idea stolen or protected one just in time? And remember, if you create, you must protect. Because in the world of intellectual property, ownership is not a killing, it's a legal fact.